This 1961 High Court case is an important case regarding the foreseeability of harm in negligence law. Chapman was driving his car in poor weather conditions late at night and was not sufficiently careful. He collided with another vehicle. Chapman, who doesn't seem to have been wearing a seatbelt, was flung onto the road and injured. Dr. Cherry, who was passing by, stopped to help Chapman, but this put him on the road, in the rain, at night. The unfortunately named Hearse, driving past, did not see Dr. Cherry. He struck and killed him. An action was brought on behalf of Dr. Cherry's widow and children against Hearse. Hearse argued that 25% of the damages against him should be paid by Chapman, because if it were not for Chapman's negligent driving, Dr. Cherry would not have been on the road, and Hearse could not have hit him. The question, though, was whether the harm to Dr. Cherry was reasonably foreseeable as a consequence of Chapman's negligence. You only have to take care to avoid harm that is reasonably foreseeable. And Chapman argued that it wasn't reasonably foreseeable that a doctor would be passing by, or that he would be required to be on the roadway, or that he would be struck by a car. The court disregarded the fact that Dr. Cherry was a doctor, and instead said that Chapman should have been aware that by driving negligently he might cause an accident and people might come to help, and that by doing so they would place themselves in danger. Chief Justice Dixon, together with Justices Kiddo, Taylor and Windier, said, "It is, we think, sufficient to ask whether a consequence of the same general character was reasonably foreseeable, as one not unlikely to follow a collision between two vehicles on a dark, wet night upon a busy highway." Those judges went on to say the following words which really express the ratio of this case. "It is not necessary for the plaintiff to show that the precise manner in which his injuries were sustained was reasonably foreseeable. It is sufficient if it appears that injury to a class of persons of which he was one might reasonably have been foreseen." The result was that Chapman should have foreseen potential injury to rescuers and should not have driven negligently in the first place. He was liable for 25% of the award.